Good afternoon, everyone. My name is Larry Sandigo, and I am the Director of Outreach for Congressman Greg Stanton. We are thankful that you have joined us today for our housing webinar for tenants and homeowners. Unfortunately, Congressman Stanton could not be here today. He wanted to welcome everyone personally and thank you all for participating, but he's on a flight right now to DC, and so he asked me if I could read a few words on his behalf. Good afternoon, everyone. This is Congressman Greg Stanton. I want to welcome everyone joining us today for our housing webinar for renters and homeowners. So many joining us this morning and many more in our community are facing challenges we never imagined possible. Every single day, my team and I hear from folks who are hurting. They're worried about making ends meet. They're worried about how they're going to pay rent or the mortgage. Maybe they've lost their job or closed the door of their small business and they need financial relief. So before I turn it over to our experts, I want to briefly give an overview of the work we've been doing in Congress. At the very beginning of this crisis, our #1 priority was testing and public health. We allocated $8.3 billion to immediately increase our medical response and ramp up state and local efforts to combat this pandemic. Then we passed the Families First Act, which ensured coronavirus would be free to anyone in need, regardless of medical insurance. It provided emergency paid sick leave, enhanced emergency unemployment insurance. It allocated more than $1 billion to expand food assistance programs and much more. In late March, we passed the latest and largest of 3 stimulus packages, the CARES Act. With a $2 trillion price tag, it was the largest spending package of American history. It just gives you a sense of how serious this moment is for our country. One of the main provisions of this bill throughout was to give relief to American families. That included passing measures that protect tenants who are in federally subsidized programs and who live in properties with federal subsidized mortgages. These tenants will be protected from evictions during this time period and during the recovery period. Many aspects of housing law and tenant landlord law are controlled by the state. However, I thought it was important that you have this information. There's a lot of misinformation circulating, and I want to make sure that my constituents have access to accurate and reliable information. That's why I've asked experts from Community Legal Services, the Southwest Fair Housing Council, and from the Maricopa County Justice Courts to answer your questions about housing, evictions, foreclosures, and other relevant matters. I'm going to keep working and fighting to meet your urgent needs and make sure we all come out of this as secure and stable as possible. We're already working on a 4th stimulus package that will include more support for families in need. I'm sorry I couldn't join you, but I hope you find this information helpful. So that was on behalf of Congressman Stanton. I just wanted to quickly go over today's agenda and do brief introductions. The first part of the webinar will cover tenants and homeowners' rights and obligations and resources under COVID-19. Then we'll turn it over to hear about fair housing issues during COVID-19. Then we'll hear about how to access justice courts during COVID-19. And lastly, we will answer some of the questions that were submitted beforehand. So with that, I want to turn it over to Pam Bridge, who's the Director of Litigation Advocacy with Community Legal Services.
Thank you. We'll go to our first slide. I want to thank Congressman Stanton's office for inviting me to speak about these issues today. It is complicated, so we hope we clarify some issues and are happy to answer questions after this presentation at a later date about the things I will present. So Community Legal Services is a nonprofit law firm dedicated to advocating, litigating, and educating low-income individuals concerning their civil legal needs. We help individuals with housing, family law, consumer benefits, and employment. Today I'll be focusing on housing though. Next. We assist individuals in 5 main areas: Maricopa, Yavapai, Mojave, La Paz, and Yuma. Although those are the areas that we can advise and represent clients, we provide statewide assistance. And today I will be going over law that is applicable to our entire state. I will be discussing the Governor's Executive Order 2020-14 and as Larry also stated, we'll be discussing the CARES Act, which is a federal protection for tenants and homeowners. So next, let's start with the Governor's Order 2020-14. So what the main thing this order does is, in certain situations that we will go over, it stops a constable or sheriff from locking a tenant out. Tenants must still pay rent. It does not excuse tenants from paying rent. Tenants must still pay rent to their landlords. And landlords can still get judgments against the tenant. And in fact, even if the constable or sheriff does not lock the tenant out, the judgment stays on the tenant's record, and it can impact finding other housing or being accepted into subsidized housing programs. So let's get down to what the executive order allows. Next. So what it says is that a tenant can stop from being blocked out by a constable or sheriff if the tenant gives to their landlord or property manager a notice if any of the following circumstances apply. The tenant has been diagnosed with COVID-19 and must be quarantined. The tenant has been ordered to self-quarantine by a medical professional because of the symptoms as defined by the CDC. That someone in the household has been diagnosed with COVID-19 and they must be quarantined. The tenant has a health condition by the CDC that makes the tenant more at risk for COVID-19 than the average person. Those health conditions are listed on the CDC website, and they include asthma and pregnancy and other conditions. Or the tenant has suffered a substantial loss of income as a result of COVID-19, such as they lost their job, or they have reduced pay, or their workplace is closed, or they're required to stay home now because our schools are closed and they have reduced hours at work or were laid off. So what has to happen in order for this protection to apply is that the tenant has to give the notice to the landlord, and it can be by email or text. And the order says that when they give this notice of to the landlord, that they also attach any supporting available documentations of the above situation. So next. Just so you know, a copy of this notice that tenants can give their landlords is on the Community Legal Services website. I want to point out that at the top it says July 25th. That is just until the order applies. The tenant, this only keeps the tenant from being locked out this one time. The next month, if the landlord again wants to evict the tenant, gets a judgment, the tenant again would have to prove these conditions and that they still apply. So even though the law is effective until July 25th, this protection only applies to the actual complaint that was filed against the tenant. If the landlord files a new complaint against the tenant and the tenant gets a new judgment, they are once going again to have to show this information to their landlord. Next. So a couple things. So let's say that a tenant gets a copy of an eviction notice. The first thing is that the tenant should do is call the court. I'm going to allow Judge Driggs, who's going to talk about the current, the manner of accessing our courts right now. However, it's really important that if the tenant does give a notice to the landlord or manager, and then the landlord or manager gets a judgment against the tenant, the constable can still come to the tenant's house. It's really important that the tenant have a copy of that notice and available documentation to show the constable when they come to their house, because that way the constable knows that they complied. If that happens, the constable will not lock the tenant out. At that point, and that is happening right now throughout the state, that the constable is coming to tenant's home sees the notice and the available documentation, and for one reason or another is deciding to lock out the tenant. At that point, the tenant should call an attorney like Community Legal Services. Even if they contact us the very next day, there may be things that we can do about it. But it's important, what we're seeing throughout the state, not just in Maricopa County, is that tenants are not providing this notice to the landlord before the constable comes. So just make sure as soon as you know you have these qualifying conditions, you hand a copy of the notice and any available documentation that you have. For instance, maybe you have the last paycheck from your employer. On our website, we are giving sample documentation that you can have from your doctor or your employer that can assist you in having available documentation. But again, make sure you keep a copy of what you gave the landlord so you can show the constable that you did this. And that will keep the constable from locking you out at that time. You will still have the judgment on your record. At the end of this order, you will be locked out. You can be locked out. And so this is just delaying you from being locked out so that you don't have to look for other housing at this moment. Briefly, before I go on to the CARES Act, I want to just touch on the fact that the governor also ordered an executive order for commercial tenants. Commercial tenants have a protection if they are most types of small businesses, as long as they have less than 500 employees, that until May 31st, if they have any financial hardship related to COVID, they can again tell their landlords, and they can show any available documentation. And for them, the landlord cannot lock them out or even begin to give them a notice to vacate. And that's an important factor. So if a commercial tenant gives a notice to their landlord of a financial hardship related to COVID-19, the landlord cannot begin to evict the commercial tenant through May 31st. The order also says that commercial tenants are encouraged to reach out to landlords to try to get lower amounts of rent, and the landlords are encouraged to take that. However, that they are not ordered to do so. I'm now going next, we'll move on to the CARES Act. So we talked about the governor's order that applies, that's a state protection for all tenants. The CARES Act, as Larry said, is a federal protection, and it applies to tenants in many of our federally subsidized programs, and also tenants who live in properties with federally subsidized mortgages. Landlords cannot charge any of these tenants late fees or file eviction complaints against them for non-payment of rent. So as I mentioned, under the governor's executive order, landlords can still file eviction complaints against tenants. However, under the CARES Act, for these tenants living under federally subsidized programs and tenants with federally backed mortgages, landlords cannot even file eviction complaints against them for non-payment of rent. This applies for 120 days beginning March 27th. It's important to know that these tenants still need to keep paying rent, although they can't be evicted for non-payment of rent. That obligation continues, and at some point they're going to be required to pay that. So next slide. Let's talk about who this applies to. First of all, it applies to all tenants that are living in these listed types of federally subsidized housing. And we've listed the types that it applies to, and that includes public housing, Section 8 vouchers, which is very common in Arizona, tenants who live in low-income housing, tax credit housing, and you can see that list. That list is also on our website. Sometimes tenants don't know if they live in federal subsidized housing, so they can look at their lease to find out. Under Section 8 programs, there will be a HAP contract. There's a HAP contract involved. There'll be attachments involved. It'll be listed in their lease. If they live into low-income housing credit, you won't see anything about HUD, but you will see in the lease something mentioning the IRS code section 42. So this is really important. This applies to all of these tenants who are living in federally subsidized housing programs, because there are thousands of tenants in Arizona who are participating in these programs. It also applies to federally backed mortgages, any tenant who's living in a property in which there's a federally backed mortgage. Next. So a couple things. As I said, the tenant, if they get a complaint and they are in a federally subsidized program for non-payment of rent, they should appear at their hearing and make sure they tell their judge that they are in a federally subsidized program. They can look on their complaints. Complaints in Arizona have to say whether it's subsidized or not. That doesn't tell us what type of subsidy it is, because there's state subsidies also, but at least it's a clue. If the landlord does makes them try to pay late fees or tries to evict them, we really encourage them to call Community Legal Services or our other legal services programs in the state, SALA near Tucson, and DNA up north. Again, tenants must keep paying rent, and also if the tenant is living in a federally subsidized program, a federally backed mortgage, sometimes it's really difficult for tenants to know that or not. How many tenants know what type of mortgage their landlord has? However, they can go online to a federal database which states whether they have this. And another thing they can do is ask their landlord if they have a federally backed mortgage. Again, if they go on to the Federal Mortgages website, there's a database that states most properties that have federally backed mortgages. Next. So how do we get rental assistance? The Department of Arizona has rental assistance currently for tenants who are unable to pay rent because they have COVID-related hardship. It has to be related to COVID-19. We know a lot of tenants in Arizona have problems paying rent, but this protection is for tenants who have COVID-19 related hardship. If they want to, as soon as they know that they're having problems paying rent, first of all, tenants should always contact their landlords and talk about that. Communicate with their landlords to make sure that perhaps there's a payment plan, something they can enter into in writing. If they're going to reach out for this type of assistance, they should go on to this website that we've shown, and they should look at the FAQs, because there are some eligibility requirements to get this money. Next. For instance, tenants their income has to fall at or below 100% of the area median income adjusted for the household size. This chart that I've listed is also available on the Department of Housing's website. But you can see that your income and your household size have to be under the amount listed. Importantly, tenants will still need to pay part of their rent. They will be required to pay 30% of their rent, of the income for the month before they apply. So let's just say that you apply in April and because you lost your job in April because of COVID-19. The Department of Housing will look to your income in March and require you to pay 30% of your rent, 30% of your income for rent. That's really, really important because a lot of tenants don't have that, so they should try to save that amount. The Department of Housing's website, There's thousands of people per week that are trying to receive this money. So the first thing you want to do is tell your landlord you're applying for the money. You need to make sure that you pay your part of the rent on time, because there has been a significant delay in getting money from the Department of Housing right now, just because there's so many people who are applying. So make sure that you pay your 30%, the amount that the Department of Housing says that you're going to need to pay, and you pay it on time, because you're still required to do that. And if the landlord accepts your part of the rent without asking you to sign a waiver, then they can't terminate you for non-payment of rent. Next. So mortgages, we're going to move on to homeowners right now. Mortgage protection, state and federal. The governor has an agreement with the banks that they will not foreclose currently. And there are a couple of huge protections under the CARES Act for individuals have mortgages that are federally backed. First of all, for the next 60 days, actually I think we're at day number 51 now, that they cannot be foreclosed. If you have a federally backed mortgage, you cannot be foreclosed for this period of time. It began on March 27th, for the next 60 days after that. And that's regardless of whether the homeowner has any problems related to COVID-19. So that's a huge protection. So if the homeowner is having problems what they should do is go and they can ask for 180-day forbearance. And that is for all federally backed mortgages, you know, Federal Mac, FHA, VA, HUD, USDA. They need to ask for the 180-day forbearance. They don't need to show any documentation. They just have to attest that they are having a problem paying their mortgage, and they can get that 180-day delay. So what happens if you have other types of mortgages through private lenders, then the homeowner should reach out to their mortgage servicer. And you can find that number on your mortgage statement or your coupon book, and you should find out if they have a hardship program. So the protections that I'm talking about are only for the federally backed mortgages. If you have a private mortgage, you're going to have to reach out and talk to your mortgage servicer and see if there's a plan that you can receive. Next. There's also, the state of Arizona is also offering mortgage assistance. Again, you can go back to the housingaz.gov website. It's under Save Our Home AZ. Before you apply for these funds, make sure you look at the eligibility requirements. You can't be within 30 days of a trustee sale. Your mortgage can't be more than $500,000. But you can receive mortgage assistance through this program. And those are, I think that I've reached the end. So I'm going to now hand it over to Cheri from Southwest Fair Housing.
Great. Can you hear me now okay?
Yes, we can hear you.
Okay, perfect. All right, so Southwest Fair Housing Council is a nonprofit grant-funded fair housing organization which serves all Arizona communities through grant funds. We work to eliminate all forms of housing discrimination through education, outreach, and enforcement. Our enforcement department does investigate discrimination claims and helps people file complaints. But before I get into the COVID-19 pandemic and fair housing protections, I wanted to give you a quick base on the federal fair housing protected classes. Fair housing is the right to live where one wants without being discriminated against because something about them as a person. And that is where the law specifically lays out the federal 7 protected classes. If you're involved in housing in any way or an advocate for yourself or others, you must know these protected classes and what they mean. So know that we also at our organization have free fair housing classes that you can sign up for. Next. Most commonly when people think about discrimination, they think of intentional discrimination or purposely treating someone differently based on one of the 7 protected classes. However, in certain instances, it may be possible for even unintentional discrimination to be considered unlawful. Knowing and understanding the rules in fair housing along with its nuances is definitely key in preventing housing discrimination under the law. So let's talk COVID-19 and fair housing. Next. Fair housing laws protect people who are infected with COVID-19 and those who are perceived as being infected. Next. The state and federal fair housing laws prohibit discrimination based on national origin. So it is illegal to deny you housing or shelter because you're from one of the countries most affected by COVID-19 or you're perceived as being from such a country. It is illegal to have different rules for you than everyone else because you're from one of the countries most affected by the COVID-19 or again perceived by being from that country. It is also illegal for a housing provider to send you a notice to quit or try to evict you because you are from one of those countries most affected by COVID-19, or even if they perceive you as being from one of those countries. It is illegal for your neighbors to harass you because you're from one of the countries most affected, again, by the COVID-19, or the perception is another protection in there if they perceive you from being from such a country. Next. Additional protections may be there for persons who are defined as disabled. The state and federal fair housing laws prohibit discrimination based on disability. If you're infected with COVID-19, you may be considered disabled under the state and federal fair housing laws, and you may be protected from discrimination. If you do not have COVID-19, but a housing provider denies you housing or shelter because they believe you have the virus, this is illegal, and you should call Southwest Fair Housing Council or go online to report it. If you do not have COVID-19, but a housing provider quarantines you or imposes different rules on you because they believe you have the virus, this too is unlawful, and you should call Southwest Fair Housing Council. Next. If you are disabled or unable to perform such tasks as walking or breathing or going up and down stairs or other important life activities because COVID-19 has left you permanently disabled, you may be able to get a reasonable accommodation from your housing provider. A reasonable accommodation is a change in the rules, policies, or practices, like allowing you to have a home health aide or allowing you to park closer to your unit because of a disability, or maybe even having an animal which is connected to a particular disability in a place that doesn't allow pets. So how do you get a reasonable accommodation? Next. There are a few principles that will help anyone requesting and receiving a reasonable accommodation easier. If the disability is obvious and the need is not clear, or the disability is not obvious and the need is not clear, it is not unlawful, meaning it is permissible for a housing provider to ask you about the nature of the disability and how the request is connected. Be sure that you talk to your healthcare provider about any needs that you may have. Put all your requests in writings as well as a precaution. So who is a healthcare provider? Next. This is not an exhaustive list of healthcare providers or / professionals. The mistake here made most often in fair housing is people are told that their letter must be from a medical doctor, and that is incorrect. It has to be from a healthcare provider, or what the new 2020 guidance shows, they're using the term professional. But this is about a reliable third party who's in the position to know about the individual's disabilities and the changes necessary to afford a person with a disability the equal opportunity and use to enjoy the dwelling, and not only the dwelling, but the amenities associated with that dwelling. So if your reasonable accommodation gets refused, please contact our office. Next. Next. Can you hear me?
Hi,
Larry,
Cheri, this is your last.
Yes. Oh, I thought there was one more. Okay. Oh, there is. Okay, so making disability-related inquiries without a legitimate, non-discriminatory reason could violate the Fair Housing Act on the basis of disability. Be sure before housing providers, before making any housing-related decisions on the basis of disability, to seek legal advice. Be aware that the Fair Housing Act and other fair housing laws prohibit the eviction, turning away, or harassment of persons in housing because they are profiled on the basis of race, national origin, or other protected classes to be associated with COVID-19. And I believe you're right. Now, this is my last slide, and I will turn it over to Judge Driggs.
Thank you, Cheri. Judge Driggs, thank you so much for joining us. Judge Driggs is the Justice of the Peace in the Maricopa County Courts for the Biltmore Arcadia Precinct. We are fortunate to have her here to talk about how to access justice courts during this time period. Judge Driggs?
Hi, thank you for having me. All right, so I'm going to follow some of the questions. We'll follow along with the questions on the slide. So the first way for tenants and landlords to find out about the temporary procedures that we have during COVID-19, the best place would be to go to our website, Maricopa, it's justicecourt.maricopa. And so we have a website, and it has all the procedures, and it's updated daily, weekly. Whenever we have changes, it is being updated for you to know how we're handling things. And right now, the best thing is to look at the website or call the courts. The court that's listed at the top of your paperwork that you have. If you're a tenant and an eviction was filed against you, the paperwork would be at the top. Or if you know which precinct you're in for the landlord, you would call your justice court. There are 26 of us in the Maricopa County Justice Court. And then the next question is, how do tenants file fee deferrals? You know, and that's a good question because a lot of tenants don't know about fee deferrals. And we try to train our staff members to offer that at all times. Anytime that you answer a lawsuit in the courts or you want to file anything, there is a fee. But you can always apply for a fee deferral, and the staff at the window will give you that paperwork, and notaries are not required. And original signatures are required, but I believe at this time we're allowing faxes and emails with your signatures on it. And then the next question is, how do tenants and landlords file complaints, motions, and exhibits if hearings are virtual? We are still allowing people to come in and file complaints. A lot of landlords have attorneys. The attorneys will send runners. But if you're doing this all on your own, you know, we're allowing limited numbers of people to come in and file what they need to file at the windows. But the best practice first would be to call from your home just to be safe so that you can stay at home and avoid any exposure to the virus. Call the court and ask the court what do you need to do. A lot of things are being allowed to be emailed, mailed, and faxed. And it's asked how the telephone hearings work. So what we have now are virtual courtrooms. And when you're getting sent paperwork for a court hearing, the paperwork should tell you a number to call and what time to call to be in that virtual courtroom. Some of the judges aren't using the virtual courtroom, but most of us are. And once you call that number, then you'll be given an access ID and dial all the numbers that they instruct you to do, and you'll be put in a courtroom, and you just need to wait. Sometimes there won't be any sound because people are waiting for the judge to come and call the court to session. And then once you hear the judge, just listen for your name. I know that there have been situations where, you know, if you're on hold for a long time or you're just, you know, doing other things while you're on mute and you're waiting for your name to be called, you might miss your name. Generally, you're given a time frame, and it should be a time frame of about an hour, and courts are trying to, you know, stick to that time frame. If, you know, we're going over and we know that you were there on the phone call, some judges will call your number if you have provided us with your phone number so that we can say, you know, we called your name, you weren't there, but we knew you wanted to be heard. And some judges will actually make that extra effort to call you if you weren't there and they knew that you had once been in there or you had called the court to say you were planning to appear. I know I've done that with people that I know had called, but it seemed like maybe they were having difficulty being in the virtual courtroom. So I went ahead and called them on a conference call so that they could appear. I know that I am, and I know that the other 4 courts in this downtown Justice Center, we are working really hard to be helpful to both parties, you know, because we know that it's a difficult time for everything to be telephonic. We're all doing our best to make the courts accessible and not make it more difficult because of the virus. And we have seen now that in the eviction actions, more people are appearing and being represented, where before there'd be a lot of default judgments because people just didn't appear. Now we are seeing a lot more appearances by telephone, so that's a good thing. The next question is, can a tenant or landlord request a jury trial or trial right now, and how will that work? Well, at this point, they've suspended all jury trials. I'm not sure how it would work. I haven't had a jury trial request at the moment. That's a good question, and I think because we're not having juries, it would either have to be suspended or, you know, continued. The case would be continued for a while. It would depend on the plaintiff and the defendant. If the plaintiff is represented by an attorney, they may have certain requests. If the tenant or the defendant asks for a jury trial, you know, we would hope that they'd be able to just work something out, since it would be very difficult right now to get a jury. We aren't even calling juries at the moment. And I guess, you know, we would just have to continue that for when juries are starting to be called. And, you know, with the governor's executive order, a lot of things are being delayed as far as evictions, the constables enforcing evictions. So, you know, everything's waiting anyway. And then some tips for litigants appearing by phone. So I've kind of covered it. You know, call in, make sure that you know there might be silence and you may be in there. If you want to, you know, speak up and say, can anyone hear me? Then you can at least know that you're in there. There may be someone else who's waiting and they can let you know, yes, you're in the right courtroom. Maybe call the day before. I know that sometimes people aren't sure they're in the right courtroom or if they can be heard. They're a little bit confused, and then they might hang up and then call the regular line for the courts. And those lines are very busy right now. Right now, so many people are calling the courts that you can be on hold for a long time. And if you call the court's regular phone number, you might get put on hold for 20 minutes, and then you might miss your hearing. So don't make that mistake. Just try to call the day before, make sure that the court knows you're planning to appear for that hearing, and then provide your phone number. That way the judge will know, or the clerks will know, that you were planning to be there and that they have a phone number for you, so that if you happen to miss your name being called, or if you dial the wrong phone number, or you can't make it work to get into the virtual courtroom, the judge or the clerk will call you and say, you know, you haven't appeared, but we know you wanted to appear. Do you want to talk to the judge now? And then we can reach out to you if you're not there and we knew that you were planning to be there. And I think that's it.
Driggs, thank you so much for that really helpful information. We are now going to go over to the questions part of our presentation. Many of the questions that our constituents submitted have already been answered through this webinar, but folks, you know, have a lot of questions about how this works. And so we're really thankful that you are all here to answer our questions. So I'm going to ask the questions as they were submitted. And any of the 3 of you can feel free to jump in and answer the question. Are there protections for landlords who rely on rent payments to make ends meet?
I can take it. This is Pam. First of all, landlords have all of the protections under the Landlord-Tenant Act. So if a tenant does not pay rent, as long as they're not in a federally subsidized program or federally backed mortgage, landlords can file complaints against them for non-payment of rent. And so also if a tenant doesn't pay rent, then that, and it's related to COVID-19, then a landlord, if they have a federal mortgage, could ask for their mortgage payments to be delayed. So they have that federal protection also. But all the protections under the Landlord Tenant Act for tenants and landlords continue. So in that situation, if a tenant doesn't pay rent, again, if they're not, as long as they're not in a federally subsidized program, the landlord can file a complaint for non-payment of rent against the tenant.
And Pam, let's say the tenant is in some sort of federal program or federally subsidized. What recourse does the landlord have?
So let's say that first of all, in that situation, they can't file and they can't charge late fees, but that tenant still will owe the rent. Because they're in the federal subsidized program, that landlord is, if they are going to be able to get a deferment if they have a federal mortgage, which is something they should do. But at the end of the CARES Act only runs again until July, and then it gets extended to August. The landlord will be able, that rent is still due to the landlord no matter what. So if a landlord's in that situation right now of a federally subsidized tenant, first of all, I would encourage the tenant to reach out to the Department of Housing to see if they can get rental assistance. The landlord should then see if they have a mortgage, get their mortgage deferred. But they can still get, at the end of this, a judgment against the tenant for that monetary amount. The debt to the landlord is not going to go away just because it's been delayed.
Got it. Thank you. A question about rental assistance. Are renters eligible for rental assistance if they are not past due?
Yes, they can, as long as they're having hardship related to COVID-19, they can get rental assistance. In fact, as soon as they know that there's a problem, they should start seeking out that rental assistance and not wait till they're past due, just because, as I mentioned, it takes so long to get it right now. And no matter what, they should make sure that they are paying at least part of what the rent that they can pay on time.
Okay. Another question. Should landlords be offering rent reductions since they have closed common amenities like the gym, pool, clubhouse, etc.?
Well, they're not required to. Again, the Landlord Tenant Act continues. So a landlord doesn't have to reduce any fees or payments right now to tenants under the governor's order or the CARES Act. But again, what I would suggest, if tenants are having problems paying fees, that they communicate with their landlord. We've heard that many landlords are trying to work with tenants and reduce fees because they don't want their tenants out. So in that situation, if the tenant can't pay types of fees for extended things, that they go and talk to the landlord.
Thank you. We had a few constituents submit questions around that they've filled out an application for rental assistance due to COVID-19 job loss, and they've received a case number, but it's been, we have one constituent who's been waiting for 3 weeks, another one who's been waiting for 2 weeks, and you know, they're wondering, is that standard? You know, how does that part work, and what do you do if you have a problem with?
And I think because this was all this money came to the Department of Housing, they are having some growing pains. So it's not that this was a situation for them before they received this money and before the COVID-19 money. We've heard about many problems like that and many delays. So what we suggest that they do is to if the caseworker, if the person is not calling you, to continually to call them and make sure that you have the right community agency. Sometimes they get confused and you get assigned the wrong one. So you want to be proactive in contacting the Department of Housing assigns the community action agency to work with you. You want to then continually be proactive with the Community Action Agency to make sure that you've got all your documents in, and if you haven't heard from them, continually call them. And then you also, again, at the same time, communicate with your landlord that you are doing this and you are making these attempts.
Thank you. Cheri, we have a couple of questions for you. Is a housing provider required to care for a service animal for a tenant with a disability who's unable to care for the animal because of COVID-19?
Yeah, a housing provider is not responsible for the custody or control of a service or assistive animal if the tenant is not able to care for them. The new guidance that was out from HUD on animals in housing in 2020 states that it makes it very clear that a person with a disability is responsible for feeding, maintaining, providing care and control over their assistive animal.
Okay. A related question to housing is what special precautions should be taken by maintenance workers when doing a work order for a resident who has COVID-19 or they think might have COVID-19?
Well, precautions should never be special. They should be a standard for the type of work order and not for the resident. So, for example, if anyone's working on a toilet, it doesn't matter whose toilet it is. It makes sense to wear gloves and spray with bleach. If you're worried about catching airborne diseases from residents, feel free to wear a mask. Just wear it around everyone. Every community should have its own work order protocol as to how each type of situation would be handled, but not treat it because of the person.
Okay, thank you. And one last question for you, Cheri, is does the FHA require a housing provider to provide a transfer for a tenant who is living near someone who has symptoms of COVID-19?
This type of request could be considered a reasonable accommodation if the individual is requesting the transfer for another permanent or chronic condition that compromises their immunity. So it could be a reasonable accommodation request.
Okay, thank you. So unfortunately, folks, that's all the time that we have for questions, but for those who submitted questions and it did not get answered, our office will do our best to have it answered and sent to you. And before we wrap up, I wanted to ask if the three panelists could just say, if there's one thing that you wanted folks to take away from what you said, what would it be? So let's start with you, Pam, go to Cheri, and then Judge Driggs.
I guess the first thing I want to make sure is that everyone's communicating so that if the tenant's having problems paying their rent, that they don't just give up, they reach out to their landlord, they look at the different resources, they make sure they understand their rights. If a landlord or homeowner are having problems paying their mortgage, they also need to reach out. The only way they get that deferment if they have a federal mortgage is taking the time to talk to their mortgage lender. So I would say what I would take away is for everyone just to try to communicate as much as possible right now in hopes that we can work out things that don't involve the courts.
I'd say let's do our part and know the facts when it comes to COVID-19 and stop the spread of rumors. Be sure, as she's already said, communication is paramount. This is an important time to talk, and it's an important time to make sure that your communication is understood. So if you have troubles in fair housing, reach out to our agency, but let's not worry about where this disease came from and treat people differently. Let's look at it as equality and that everyone has the rights to be able to live together and harmoniously as much as possible. And there are lots of things on the CDC website that you can post that will help keep the rumor mill down.
Thank you.
And I would agree with Pam, communication is key. So the same with the courts. Be sure to be in communication with the courts and don't wait until the last minute. You don't want to miss your hearing. Call the courts, make sure that they're able to call you back. And one thing to remember is whenever the courts call you, it's going to look like a private, unidentified number, or it may look like all zeros. So if you know the court's going to call you, just answer the phone if it says unidentified caller or all zeros, because that's us.
Thank you. Just as we wrap up, I wanted to put on here the contact information for the two agencies, their websites and their telephone numbers for folks who are experiencing difficulty. Both of these organizations are here to help, and they will do their best to help you. And here's the website again, for Community Legal Services, for Southwest Fair Housing Council, and for our office, stanton.house.gov. We are trying to put as many resources as possible and continuously update our website with new and relevant information. We know that this is a fluid situation and that things can change. New orders can come down, new laws can be passed, and so we will do everything we can to keep you updated so that you are in the best position possible. And just a reminder is that the Office of Congressman Greg Stanton is here to help. If you have any follow-up questions, if something didn't get answered or something wasn't clear, we are here to help. Our phone number is 602-956-2463. Because our caseworkers are working from home, no one will pick up the phone, but you will leave a message and someone will call you back. You can also submit an online inquiry at stanton.house.gov and someone will respond to you. I wanted to thank our panelists again, Pam, Cheri, Judge Driggs, for your time, for your expertise. This information was really helpful to our constituents, and so we thank you so much for what you're doing now, but what you've been doing in the years before to help tenants.
Thank you.
Thank you again, and that concludes our session.
Thank you so much. Have a good day.
Thank you.